Hi, this is Jordan Walker with Seaver Walker Paget Law Firm. I'm here to talk about eminent domain in the state of Georgia and the DeRenne Road Project. This is for landowners affected by that road project. And with that being said, we're going to go ahead and get started. Again, this is Jordan Walker with Seaver Walker Paget Law Firm. We are an eminent domain only, landowner only law firm located in Alpharetta, Georgia. Today, as I indicated, we're going to be talking about the DeRenne Road Project. We're going to be talking about eminent domain in the state of Georgia, what to do when the DOT or the city wants your land, and we will share important components to your case. First, why did you receive a letter? If you received a letter, it's because our information indicates your property is likely affected by the DeRenne Road Project in Chatham County. Even if you're not sure if your property is affected, ultimately you will be contacted by GDOT, by the city, if your land is necessary for this project. There are many steps they need to take prior to acquiring land. So that's why you received a letter. And if you are affected by the project, ultimately you will hear from either the city or a county or GDOT, whoever is acquiring the property. Real quick about our firm, a little bit more. We are eminent domain attorneys. This is the only area of practice that we do. We only represent landowners affected by eminent domain projects. We do this in multiple states, including obviously the state of Georgia. I am licensed in the state of Georgia, in addition to several other states as well. Our mission today is to relay information, relay our experience that we've accrued over the years, dealing with these projects, dealing with the DOT, dealing with eminent domain. Again, we do not work for the DOT. We do not work for condemners. We are landowner only. And with that said, we'll just go ahead and get further in. The DeRenne Road Project, also known as Project DeRenne, it's in Chatham County. It is a new road in addition to some intersection improvements. You can see the project map right there, where they are actually building new road. It's in obviously the city of Savannah, and it's actually three different projects, all affecting either West DeRenne or East DeRenne. And you can obviously see the map right there. It's not a gigantic project, but there are quite a bit of properties affected. What is eminent domain? Eminent domain, put simply, is when the government seizes your land for a public use, for a public need, such as, for example, a road project. Road projects are the most common or most traditional methods of eminent domain, the ones people think about the most. But eminent domain can be exercised by power lines, pipelines. All sorts of entities have this ability to acquire private property and put it to a public use or public purpose. So while they can take your property, they can seize the property through the court system. They do have the obligation to pay what's referred to as just compensation. And just compensation means that if necessary, and if the landowner desires, they have the option to present their evidence. Actually, both entities, both parties have the opportunity to present their evidence on what the landowner is entitled to in front of a jury of your peers, of the landowner's peers. The jury can then determine just compensation. Ultimately, again, what this means is that if it reaches this point, it isn't necessarily what you aren't entitled to necessarily what the DOT thinks you're entitled to. You aren't necessarily entitled to what you believe you're entitled to. Ultimately, you could be, if presented to a jury, you would be entitled to whatever the jury determines you're entitled to. That would be the verdict, so to speak, determining just compensation. GDOT and the city of Savannah counties, governmental entities have inherent eminent domain authority in the state of Georgia, which means they can file suit as a matter of right. And their right is not delegated by any other entity. The eminent domain acquisition process for roads in the state of Georgia is there's a uniform process. There are requirements that any entity needs to follow for a road project prior to initiating an eminent domain acquisition to take the property. The first step for a landowner would be the appraisal inspection. In other words, when the DOT wants to acquire your land, before they even begin negotiations, they have to send an appraiser out to your property who inspects the property. And not only do they have to do that, they have to give you, the landowner, the opportunity to be present during that appraisal inspection. You can choose to be the president if you there if you'd like or not, but they have to give you the opportunity to do so. And then after the appraisal has been done, they have to come out again and issue an offer that is premised on that appraisal. And so they've done the appraisal, then they come out and they issue an offer, and then they engage in some level of negotiations. But the offer must provide a meaningful summary of information to the appraisal or to the landowner based on the appraisal. So they can't just say, this is what you can't just put some numbers on a sheet and say, this is what the appraisal says. It needs to actually, the information provided needs to be a meaningful summary of what the appraisal says to allow the landowner to be able to evaluate what the appraisal ultimately said. If if the parties can't reach an agreement, ultimately the DOT or the city will move the case to condemnation, also known as eminent domain. Condemnation is the same as eminent domain in this context. A condemnation petition is an eminent domain petition. This is how the city or DOT will ultimately acquire the land if necessary, is they will go to the court and say, we need this land for this road project. The court will transfer the property to the DOT on request from the DOT. And then assuming you are not objecting to the petition and trying to stop the acquisition individually, the case moves on to determine just compensation. However, it only does so if the landowner files a notice of appeal within 30 days of receiving the petition from the DOT. So, for example, if the DOT files their case on February 1st and they serve you on February 2nd, then you would have 30 days from the date of service, February 2nd, to file your notice of appeal. And the notice of appeal, the purpose of that is to notify the parties, notify the court that you disagree with the amount of money that has been proposed by the DOT as appropriate compensation for your property. So when they file their lawsuit, if they think you're entitled to $40,000 and you disagree and think you're entitled to 60 or 70 or whatever, just disagree generally that it's not 40, you must file a notice of appeal within 30 days of receiving service. If you do not file a notice of appeal within 30 days and you do not file an objection to the acquisition in general within 30 days, your case is over and you effectively get whatever the DOT determined you were entitled to prior to the case even beginning. So it's incredibly important that if you are at eminent domain, if you have been served a condemnation petition, the clock is ticking, and you only have 30 days to file a notice of appeal if you disagree with the amount of compensation offered by the DOT. Inevitably, or eventually, I should say, the landowner and the DOT have the right to a jury trial. So there'll be a jury trial at the end of the case. If it reaches that point and the case is not resolved before them, as I indicated earlier, the parties present their evidence as just compensation owed either to the landowner presents their evidence, the DOT presents their evidence, and the jury renders a verdict. And that is the end of the case, barring appeals. So I want to talk a little bit about what just compensation means in the state of Georgia, what you are entitled to from a compensation perspective, assuming you can prove it, what components can comprise just compensation. I'm going to divide this up into partial and total acquisitions. If a partial acquisition, as you may imagine, is acquisition that only acquires a portion of your property, this makes up the large majority of acquisitions in eminent domain, where they only take a portion of it. And a total acquisition, as you might imagine, acquires the entirety of the property. It is a total acquisition. So 3 keys to a partial acquisition. First of all, of course, the value of the land. What is the underlying land or property worth? This is determined on price per square foot or price per acre determination by examining sales of comparable properties in the area. One thing to remember as a landowner is you are entitled to the highest and best use of your property, which means even if your property is being used, for example, residentially, you can put an argument, potentially make an argument that if your property is were to be put on the open market at that time, it would not sell as a residential property, but it would sell as a commercial property, and therefore be entitled to commercial land value. Something to consider if you can prove it, of course, and if you have the evidence to back it up. The second component, remainder damage, this is usually the biggest point of contention between the parties, in that it's both existence and how much damage exists. So remainder damage is shorthand for any impact that the acquisition has on the rest of the parcel. Because this is a partial taking, there will be a remnant. With any remnant, there could be an impact on that remnant because of the partial taking. Some examples of these remainder damage categories include, for residential properties, usually setback loss. If a house is closer to a road than it was previously, sometimes that home can lose value. Beyond that, ordinance noncompliance. If your property is rendered non-compliant with local ordinances, it is possible that that could have a value impact as well, which you could make an argument for and potentially recover. For commercial properties, the remainder damage categories, again, this is not a comprehensive list. There are any number of issues that can be caused by acquisitions, partial takings on commercial properties. Ordinance noncompliance, again, access limitation, reduced parking. These are all potential, these are examples of categories of commercial remainder damage that can exist. So for example, if a commercial property loses an access point, it's possible the loss of that access point will devalue the property. And then finally, business losses. This applies to any business on the property, but in order to recover business losses, the business on the property needs to be totally destroyed and cannot be replicated elsewhere or relocated elsewhere. So you may be entitled to business losses as a landowner if you can demonstrate it, and if they destroy the business on the property. And then for total acquisitions, the keys to the case are generally the same. Value of the acquisition and business losses, again, they apply to both types of acquisitions. I will say in business losses, again, since you do have to demonstrate a total destruction of the business on the property in order to recover it, if it's a total acquisition, it's de facto going to take the entirety of the business. There usually is no argument to be made that the business will be destroyed. The question ultimately then becomes whether or not it can be replicated elsewhere. And then finally, the one component of total acquisition keys that doesn't apply to partial acquisitions, and that is relocation benefits. Relocation benefits, of course, are, well, not of course, but these are benefits that landowners, tenants, anyone who's on the property that needs to be relocated elsewhere, whether it's a residence or a business, you are entitled to, in addition to the aforementioned categories of compensation, you're also entitled to relocation benefits. These are over and above just compensation. These are effectively administrative compensation packages that move the party to some other property, whatever that amount it costs. Now, there are rules, of course, to what you're entitled to. Examples, for residential relocation benefits, you're entitled to moving expenses and a differential payment. That is the difference in value between your home and the available homes on the market. You may also be entitled to mortgage interest payments if there's a concern, if there's an issue with the difference in your mortgage rate for a new mortgage versus an old mortgage. You may also be able to recover real estate fees incurred due to the real estate agent, or whatever fees you may incur because of this. For commercial expenses, you are entitled to moving expenses and reestablishment expenses. There is no differential payment for commercial relocations. And then finally, I want to talk a little bit about hiring attorneys. So these are the two typical eminent domain attorney contracts that we've seen, types of arrangements between landowners. There's a contingency fee arrangement that where the attorney's fee is contingent on how much more they get for the landowner than what's offered by the DOT. Generally, there's no retainer fee, there's no money exchanged until the case is over, and the fee is then contingent on what the attorney was able to do for the landowner. And then the second most common contract that we've seen is hourly billable rates. These are more traditional attorney arrangements where the landowner hires the attorney, and the attorney bills the attorney for their work they've done, or sorry, the attorney bills the landowner for the work they've done on the case. Usually there's an upfront retainer that's required, some amount of money that the attorney will bill against to bill against for any work that they've done on the case. And then when the retainer runs out, the attorney may ask for a new retainer or just continue to bill at their hourly rate. Okay, and that is the end of my presentation. Thank you for stopping by today. That's my contact information if you need it. Feel free to give me a call, shoot me an email. If you have any questions about eminent domain, we're happy to help out. Thank you again for stopping by, and we'll see you later.